Justice Jones Mawulom Doche, Justice of the Court of Ghana, representing the Chief Justice of the Republic, Justice of the Superior Court of Judicature, here in present. Special mention I make of my former teacher, Professor Itamin Sabosu. His Excellency, the Ambassador of the Republic, Federal Republic of Germany, Honorable Ministers of State, and I see my brother Samuel, Honorable Deputy Ministers, Honorable Members of Parliament, the Vice Chancellor of the University of Ghana, Professor Abba Apia Ampofo, the Dean of the University of Ghana School of Law, Professor Raymond Akongburu Atuguba, the Director of Education, the Ghana School of Law, Mr. Kwesi Prempeh, highly esteemed deans of law faculties in Ghana and abroad, distinguished members of law faculties in Ghana and abroad, representatives of international development partners, the media, ladies and gentlemen. It is an honor to be here this morning and to speak on a truly remarkable theme chosen for this all-important program, the future of legal education in Africa. In the discussion on the future of legal education is crucial to the sustenance of our nation, as throughout history, law has been responsible for shaping the development path of our nation. From the days of colonial domination to the promulgation of the Constitution in 1992, law has been deployed to direct the socio-economic and political course of our land. Thus, the convention executed on 6 March 1844, simply referred to as the Bond of 1844, by which the relations between the people of Southern Ghana and the British were formalized, was a legal instrument. The infamous partition of Africa was undertaken by the execution of a legal instrument described as a General Act by 14 European imperialists who gathered in Berlin from 1884 to February 1885. Indeed, the independence of Ghana was written in law through the passage of the Ghana Independence Act, which received royal assent on 7 February 1957. Law continued to shape the policies and visions of successive governments, dreams and aspirations of the people since independence. Every new administration has been ushered in by law. Even military regimes that abrogate the Constitution have been quick to put in place sets of military decrees to legitimize their reigns, as well as to formally abrogate the old constitutions. The political architecture of the current Republic of Ghana is a creation of the law. Ghana is built on a legal instrument, the Constitution, approved by a national referendum in April 1992. Did I say that the importance of a profession is assessed by its contribution to progress and advancement? There is thus no doubt that law is a very powerful profession on which the safety, development, and prosperity of the nation rest. In this regard, it is irrefutable that the quality of a country's legal education determines the quality of the legal profession. The foundations of legal education were laid in 1958 with the establishment of the Ghana School of Law. Largely accommodated in the now literally exhausted and overstretched facilities in the heart of the business district of Accra, popularly known as Makola, the school, which commenced with a student population of 97, but now has well over 2,000 in all, produce virtually all of the nation's legal resources required for Ghana's socio-economic and political development. They include President of the Republic, Chief Justice and members of the Judiciary, Attorney General, Speakers of Parliament and parliamentarians, senior public servants, judges serving on international courts, Chief Justice and other justices of the Superior in other countries like Kenya, Botswana, Zimbabwe, the Gambia, Sierra Leone, and others. International civil servants, teachers in universities in Ghana, and leading universities around the world. Evidently, the quality of products of Ghana's legal education since independence compares favorably with the very best around the world. Conversely, a contention that Ghana's legal education or law profession has served the nation poorly will clearly be mendacious or at best a gross exaggeration. In spite of this achievement, it is correct to say that the system of professional legal education is bedeviled with severe challenges arising out of the recent proliferation of law faculties and schools around or running the Bachelor of Law program without a corresponding increase in facilities for the professional law course. A consequent lowering of standards for the admission of students, substandard performances, and what have you. Mr. President, we have come far in the delivery of legal education in Ghana since 1958. A very honest examination of the facts will disclose that the system itself has over the decades, in a bid to live up to the circumstances of changing times, undergone a lot of evolution and reform. It has not been static, as some may want the world to believe, even though I hasten to add that the reform and evolution influenced over the years has not been sufficient, for the simple reason that there has not been the necessary legislative backing. Indeed, up to the 2006-2007 academic year, only products of the University of Ghana were accepted into the Ghana School of Law. The Law Faculty of the University of Ghana was the only one accredited to conduct a Bachelor of Laws program leading to admission into the professional law course. In accordance with the entry requirements of the university, excellent performance at the General Certificate for Education, GCE advanced level, and a pass entrance examination were required. The entrance examination requirement was dispensed with at a point in time, but the requirement for exceptional academic performance at the GCE A level remained a sine qua non. Most of the students were fresh from secondary school, with only a small number above the age of 28 admitted as mature students. Consequent to admission, on the basis of their first year university examinations, some students offered law were eliminated from the law faculty, and they ended up pursuing other arts or social science courses in the humanities. As only 60 were eventually admitted to pursue a degree in law going to the second year. Of the 60, the first 40, in order of merit, were selected to pursue the Bachelor of Laws program, LLB. And I'm happy to say that at least I was one of them. While the remaining 20 pursued the Bachelor of Arts degree, BA Law. The competition for admission and the justify your inclusion, as we called it in our time, coupled with the general selection process for the coveted LLB program, was such as to assure quality and produce scholarship in the students pursuing the law program in Ghana. As recorded in an article entitled, and I quote, Reflections on Professional Legal Education in Ghana, an essay in honor of Yeboah Darucha, written by George Sapon, past director of the Ghana School of Law. The situation compelled the late B.J. Darucha to regularly announce to his students at his first lecture in civil procedure every academic year, and I quote, that your knowledge of the substantive law is irrebutably presumed, end of quote. In terms, in B.J. Darucha's candid view, having gone through all these processes of refinement, a person by the time he got to law school had a strong control over his substantive law. It was not at the law school that B.J. Darucha was going to teach you any substantive law. Your knowledge of same was irrebutably presumed. It is pertinent to indicate that in order to reasonably cater for the interests of mature students, the Ghana School of Law also conducted a 2-year program for degree holders in these subjects. Successful candidates joined the students from Legon to pursue the professional law course. This program, the Qualifying Certificate of Law, QCL, was scrapped in the 2000s, with the proliferation of several law degree awarding institutions. The monopoly of the University of Ghana over the LLB program was broken in 2003 with the establishment of a law faculty by the Kwame Nkrumah University of Science and Technology in August of the same year. Since then, there has been a rocket of law faculties around the country with the accreditation of about 14 more in the public and private sector, bringing the total number of law faculties offering LLB currently to 15. Mr. President, I contend that even though on the evidence of what I have said so far, the system of legal education has undergone its own evolution and reform, the slowness of legislative reform to give proper legal backing and regulate same has proven to be the Achilles heel of legal education in the past 10 years. So, whereas the LLB awarding faculties were accredited and regulated or supervised through the mechanisms in place to regulate academic faculties of the universities, the professional law course was by law operated and regulated by the General Legal Council. This disharmony necessarily implied an inconsistency and imbalance in standards for the two vital points of legal education in the country, i.e. the academic section, learning of the theory of the law, and the professional training institutions teaching the practical rules and procedures necessary for the practice of law. The absence of effective supervision over the LLB awarding faculties, unfortunately, contributed in large measure to the prevalence of unsatisfactory conditions, militating against not only a sound academic environment, but also the production of students who were ill-prepared for admission to the Ghana School of Law. The report of a committee set up by the General Legal Council to assess faculties in the law faculties 2019, the report of a committee set up by the General Legal Council to assess facilities at law faculties in 2019 revealed very unhealthy conditions, including limited to deplorably low lecturer-student ratio, absence of or poor library facilities, the setting of low entry requirements, hugely overcrowded lecture halls, students combining professional careers with attendance and poor quality of teaching. The President, the net effect of this was a generally low pass rate of applicants for this law course. It was reported in order to meet students coming for admission to the School of Law. In a record 3 weeks, organized a whole course in environmental law for its graduating class. Predictably, all the students passed. Surely, such LLB graduates will not meet B.J. Daroche's irrebuttable presumption of knowledge in the substantive law. If we have to be brutally honest, and I dare say we must be so brutally honest at this conference, to examine the future of legal education, the huge numbers churned by the various law faculties in turn has been responsible for the unrelenting demands in the past 10 to 12 years for a liberalization of access to professional law course. In simple terms, the faculties had produced LLB graduates under conditions determined by them, and therefore they demanded admission to the Ghana School of Law for their students. I hold a fervent view that with the swell in the number of LLB holders, it has become imperative for us to rethink the delivery of legal education in Ghana. Indeed, the time has come for a proper scrutiny of the mechanisms for broadening access to legal education, whilst safeguarding the integrity and quality of the profession. Any genuine attempt at the reform of professional legal education must first address the organization, scope, and content of the LLB programs in the various law faculties or law schools. Mr. President, the destiny of the nation is at stake. A lot of honesty, good faith, and dispassionate introspection is required for this conference to achieve what I term the twin objective of broadening access to legal education whilst preserving the integrity and quality of the profession. I place emphasis on good faith because in recent times, the discussions bordering on the theme chosen for this conference has been characterized by a lot of politicking and petty point scoring for parochial ends. I will share with you a practical example. To my utter surprise and consternation, I saw a document being spread around social media and the mass media as the Attorney General's Legal Profession Bill. With unrestrained haste, various persons of high standing in society, including professors and senior lawyers, rushed to the media to make all manner of comments, virtually casting aspersions at the integrity of the Office of the Attorney General for coming up with such a bill. This they did without sparing even a split second to verify the accuracy of the information. Even though in truth and in fact, I was just a telephone call away for most of the commentators who were engaged in the commentary I'm talking about. May I take this opportunity to disclose that I have not come up with any new legal profession bill. In point of fact, there has not been any legal profession bill drafted by the Office of the Attorney General and Minister for Justice and Minister of Justice this year. No approval has been sought by me from Cabinet for a legal profession bill to be sent to Parliament, and for that matter, no legal profession bill has been submitted to Parliament. Even the most basic step we undertake as part of a process for legislative drafting, i.e. stakeholder engagement, has not been performed for any legal profession bill to be laid in Parliament. In 2019, 2 bills affecting the legal profession, one of them was the document being banned profession bill by me and laid in Parliament. The esprit of the life they preached, the bill lapsed, the team could not be considered or passed by Parliament. On assuming office of the Attorney General, I did not adopt the bill. By letter dated 2nd September 2021, I wrote to the sponsor of the legislation, the General Legal Council, presenting my comments on the bill. I asked for the chairman of the General Legal Council to present his responses to my comments on the bill. I further respectfully advised that, and I quote, in view of the fact that the bill will replace the Legal Profession Act 1960 Act 32, there is a need for a broad stakeholder engagement for the input of stakeholders to be incorporated into the bill, end of quote. I further requested in the last paragraph for background information to complete the necessary memorandum to the bill, end of quote. I merely attached a copy of the draft, which was exactly the same as has been laid in Parliament 2 years ago, to my letter, so that the General Legal Council would be guided and be in a better position to appreciate my comments on the bill and present their responses to same. In light of these facts, how can it be reasonably contended that the legal profession bill has been laid for the consideration of Parliament? It may be apt, respectfully, to reiterate an admonition I gave at the recent annual bar conference of the Ghana Bar Association, that the spread of false information poses a greater threat to cohesion in society, especially when it comes from senior lawyers. Mr. President, the nation deserves greater candor, objectivity, and more thoroughness at this all-important conference in the consideration of proposals for reform of legal education in Ghana than as has been demonstrated by some stakeholders in conversations on the subject matter in recent past. I'll proceed to make some observations on what I personally consider to be the best way to achieve the twin objective outlined above, and for the record, this does not represent a policy position by government. It is subject to discussions by all. The first observation I make is that the proposition that the existing law faculties or schools should undertake the professional law course may seem, with the greatest respect, a little rash. The proposition does not seem to take due cognizance of the fact that our system of legal education is modeled on the British system and distinguishes between the purely substantive academic aspects of the law and the practical components of legal education. Law faculties are designed and programmed to teach substantive law, whilst the Ghana School of Law sets out to focus on practical or professional legal education. The law faculties may thus appear to be ill-suited and or equipped to offer the law, to offer the professional law course. To add on the professional law course program presents a real risk of compounding the situation. Such a decision necessarily must result in a change in the policy direction of the institutions from purely academic institutions to the ones offering professional law course as well. Regard must be held to the additional infrastructure and acquisition of qualified personnel to teach a professional law course, which by their nature may not be the forte of merely a legal academic. In the spirit of maintaining a distinction between the academic teaching faculties of law and the requirement for professional training, I propose that the General Legal Council be given the power to license a number of law schools for the professional training of lawyers. These law schools will be required to undertake a professional law course in accordance with standards set by the General Legal Council. Upon the conclusion of the stipulated program, the students will be required to sit for a bar examination conducted by the General Legal Council. Towards this end, the mere possession of the LLB degree may not constitute automatic basis for entry to the Ghana School of Law, just as in other jurisdictions where they require at least a specific grade point for admission into the law school. Very importantly, the standards ought to be objective and public ought to see. The standards ought not to be static. They should be adjusted in response to the needs and circumstances of the time. So, President, the operations of a law school is a high trust and not a private enterprise for the benefit of its faculty. And as with every future, it must be treated as a stewardship for which there is accountability. Accountability to the public, to the concept of the rule of law, and to the system of legal education must have the support of the Ghana Bar and the judiciary. I cannot conclude my address without a comment on the oft-lamented low pass rate of the Ghana School of Law in recent times. The phenomenon of low pass rate in professional legal training is not peculiar to the Republic of Ghana. Neither is it peculiar to the law profession. We cannot lose the fact that professions like medicine, accounting, and what have you have similar stories of very low pass rate over the years. At the law, only 97 students were admitted, and these had to be selected out of a total of 600. The 2019 in Kenya, for an instance, only 308 out of 1,572 students who are qualified for admission to the Kenya Bar. Final examination results released by the own law school. 9 out of 179 students who sat for the examinations passed, owing to the overarching concern for the Charlotte Law School or Charlotte School of Law in the United States, fully accredited, was shut down for poor performance and compliance issues on the admission processes and practices, which were considered not to be sufficient guarantee of quality. I am aware that the pass mark for this year's qualified lawyers training scheme in the United Kingdom, which is akin to our post-core law program, was 62%. But I'm sure in Ghana, the pass mark is definitely only 50%. It is eminently clear from the instances cited above that qualification to the bar is a serious matter anywhere. It requires robust institutions and dedicated students. A poorly trained lawyer is a menace to society and a liability to justice. Members of the community can only be as good as the education they receive. This occasions for a lot of sobriety, deep thinking, or going forward, maintain, if not improve, the reputation of Ghana for a sound system. Once again, I thank of Ghana for taking the bold step to offer this platform where we bring to the fore the challenges facing legal education in Africa and an attempt to address them. It is my expectation that over the course of these 4 days, we will take the bull by the horns, thoroughly thrash out the challenges facing legal education, the way for a better future in legal education. I hope from the conference we use processes of reform of legal education in Ghana. Could this me as a set-time minister to ultimately develop a legal profession bill time for many the case to come. God bless you. God bless Samuel.
Progressive views and pending insights culminating in calls for us to be honest, show good faith, have dispassionate objectivity, and above all, thoroughness. We thank you ever so much, the Minister of Justice and Attorney General of the Republic, the Honorable Godfred Dame. I believe this is where the court can take a recess. But no. What is the bar without a bench? For which reason we're pleased this morning to receive the Acting Chief Justice of the Republic, speaking on behalf of His Lordship, the Chief Justice. Make welcome His Lordship, Justice Doche, Acting Chief Justice of the Republic.
Thank you, His Excellency Nana Addo Dankwa Akufo-Addo, President of the Republic of Ghana, Right Honorable Joseph Osei-Owusu, First Deputy Speaker of Parliament, representing the Speaker of Parliament, Honorable Godfred Dame, Attorney General and Minister for Justice, the landlady of this place, Professor Nana Abba Appiah-Ampho, Vice Chancellor of the University of Ghana, the media, ladies and gentlemen, I'll stand on all other existing protocols. Indeed, I just want to make a slight correction. My lease as Acting Chief Justice expired over the weekend. And I'm here representing the Chief Justice, who is unavoidably absent today because of a pressing personal commitment elsewhere. Thank you very much. The AG has actually dealt with a lot of the issues I'm supposed to face. So I will skip those. Paper will be submitted to Professor Reba for discussion during the course of the. I'm, however, delighted to join you here today to speak on a topic that occupied my mind. I became Chief Justice almost in Canada of the Chief Justice. He also asked me to use this opportunity to welcome the deans and lecturers of law who have joined us in the entire world, both physically and virtually. Yes, I welcome me, and I hope you enjoy your stay here to the fullest. and gentlemen, it would be counterproductive of us to attempt to carve out a future for leadership in the past and present state of legal education in the continent. The history stated, so I'll just say that the Ghanaian story is as follows. As soon as Ghana gained independence in 1957, off to put in place measures for the training of lawyers in the country. This was occasioned by growing demand by Ghanaians for legal service. That led to the Legal Practitioners Act of 1958, and the rest, they say, is history. Now, since becoming chairperson of the General Legal Council, the CJ has stated that the country has faced a lot concerning legal education. And we have always maintained that a true resolution of the problems we face requires sober reflection, effective dialogue between and among all stakeholders, and long-sighted planning. That is why this conference deserves as much support as we can give it. Over the years, the General Legal Council has collaborated with the National Accreditation Board, now Ghana Tertiary Education Commission, on a monitoring and evaluation exercise of the various accredited faculties, and we have published our findings. On the back of these findings, plans have commenced to review the development of curricula, methods of instruction, and admission criteria to the various faculties. The institutions offering the LLB program will also undergo more rigorous processes before they are approved. The criteria for assessment of these institutions will include the types of programs, the qualifications of academic staff, student-teacher ratios, library holdings, physical facilities, amongst others. Once issues of quality assurance are out of the way, it is expected that properly equipped faculties will be accredited to provide professional training, a step that will reduce the burden on the Ghana School of Law and consequently increase access to professional legal education. Quality control measures are very important. The General Legal Council has also embarked on massive stakeholder consultations towards finding a lasting solution. It is in this regard that I wish to confirm what the AG has said, that in his letter to the General Legal Council, he asked the Council to undertake broad stakeholder consultations that will lead eventually to the presentation of a bill to Parliament. So I was also really surprised to have heard in the media last week that a bill is sent to Parliament on legal education. That is not the case at all. In fact, the General Legal Council will go up to the end of January to hold the necessary sessions and report to the Council for a decision to be made. Now, what is the legal framework of legal education in Ghana? The AGA has mentioned the Legal Profession Act 1962, Legal Profession, Professional Conduct and Etiquette Rules 2020, LI 2040, Professional Law Course Regulations 2018, LI 2355, Legal Professional Employment Regulations 2020. Now, the following are the draft bills that have been mentioned in private members' bills that I'm aware of to deal with legal education reform. The Attorney General's bill to amend the Legal Profession Act is yet to be presented to Parliament. The General Council in charge of management and policy direction in respect of legal education in Ghana. The Independent Examinations Committee, IEC, conducts the examinations on behalf of the General Legal Council and the Board of Legal Education, respectively. What is the current state of legal? Is there a need for reform? The current state of legal education is not the best, hence the need for this conference. The Ghana School of Law is relative to the number of private schools. The Ghana School of Law has admitted varying number of students in various years, and the numbers have been as low as just a little over 100 and as high as over 1,000. The school is running multiple streams at the moment at various campuses, since all the students cannot be in one stream. There is a general opinion shared by stakeholders that there is a need for expansion, hence the Law Village project, which His Excellency the President, Nana Addo Dankwa Akufo-Addo, was gracious enough to cut the sword a few months ago and provided funds for the construction. Legal education in Ghana lacks a clear policy direction. The numerous changes within a short period of time concerning the structure, so the number of years should be done at the Ghana School of Law, has contributed to this complete lack of direction. There are always contentions and legal issues with entrance exams, indicating the need for a broader stakeholder consultation. The structure of the governing body for legal education may require some revision. There are two views presently advocating for the separation of legal education from the judicial service as prevails in the UK, whereas another group are of the view that the current system is adequate. The Bar Association should play a greater role in legal education as is in various jurisdictions, e.g. the US and the state and quality of legal education in the various law faculties should be improved. There was a recent report by to serious concerns in terms of quality of education in the various law faculties. The issue of the accreditation process. This is because law is a bifurcated profession. You study the academic courses in the universities and you come to the School of Law for the professional law course. As the AG refers to, it is assumed, your knowledge of substantive law is assumed. And therefore, when you come to the professional law, you do not go back to substantive law. But if you are building on wishy-washy or sandy soil, your foundation will not be strong at all. That is what we want to prevent. Quality control is very important. Based on the above reasons, there is the need for some reform in legal education. Now, we have a number of subjects taught at the Ghana School of Law. These are family law and practice, civil procedure, criminal procedure, interpretation of deeds and statutes, law of evidence, conveyancing and drafting, law, practice management and legal accountancy, advocacy and legal ethics, alternative dispute resolution, company law and commercial practice. There has been some thought that the number of 2 years spent at the Ghana School of Law is too long. So, well, at this forum, you can decide and think which of these 10 subjects can be offloaded to the faculties to teach, and those that will remain for the Ghana School of Law to teach within 1 year. If you think the 2 years is too long, then make those recommendations at the end of your discussions during the course of the week. Now, what are the other reforms that may be considered and implemented if approved? Setting up of multiple schools under the Ghana School of Law, or extension of license to law or competently run law faculties to run the law school program. That is another option you might consider. As a long-term policy that may be considered, the Ghana School of Law may be reconstituted into a certifying body and the law faculties allowed to provide legal education, provided they can do so with the qualified faculty. 3, setting down a policy plan for the next 5 years in legal education based on broad stakeholder consultations. And then setting up a committee to review the current legal structure, particularly the governing boards, to inform any changes or reforms. Government should allocate funds for the development of legal education, and an advisory committee of experts in legal education should be set up to assist the various faculties in adapting legal education to improve quality and structure at the universities. The Ghana Bar Association may be given a greater role in legal education policy as it is done in some other jurisdictions if they show their competence. 7, the accreditation process of law faculties in universities be reviewed and tightened to ensure quality control and not merely issuing of degrees to students who may not be deserving of it. The pupillage system and course content of the law school be reassessed based on the recent concern of various stakeholders about the drop in quality of graduates from the School of Law and invariably from the law faculties in the universities. The Law Village project, estimated to ramp up capacity for training by an additional 1,005 students, which I believe is another initiative that presents a commendable means of addressing the infrastructural deficit, should be pursued vigorously. With the commencement of work, I am hopeful that the edifice will be completed in due time to increase physical capacity in Ghana. Conclusion. Before I take my seat, His Excellency, the President, let me belabor the point of the importance of an intellectual and informed dialogue to finding a timeless solution to the problems that confront legal education. While this issue remains a seasonal one of interest, deliberate efforts like these to constructively discuss and profile a way forward are rare. It is my hope and the hope of the other members of the General Legal Council that we will be furnished with the report from this constructive activity to enable us to play our part. I assure you of our unflinching support towards the resolution of these problems that persist in the training of new lawyers. On this note, I once again wish you all a pleasant experience throughout the conference. May this gathering and its findings contribute to the cessation of the annual need to revisit the challenges of legal education in Ghana and aid in the resolution of what is fast becoming a continental problem. Thank you and God bless you.
We're grateful to you, our Justice of the Supreme Court, representing the Chief Justice, Justice Jones Duche. Thank you for calling us to flexibility in our methods while ensuring high quality control through a series of reforms, through our curriculum and many others. It finally stops with the Parliament of Ghana. Today we're joined by, please, are you acting or you are the first deputy? Ladies and gentlemen, the first Deputy Speaker of the Parliament of Ghana. Would you please make welcome the Right Honorable Joe Osei-Wusu.
His Excellency Danado Dankwa Akufo-Addo, President of the Republic of Ghana, His Lordship Justice Jones Duche, Justice of the Supreme Court representing the Chief Justice, the Honorable Minister for Justice and Attorney General, Mr. Godfred Dame, His Excellency Daniel Crew, the German Ambassador to Ghana, Honorable Ministers of State, Vice Chancellor of the University of Ghana, Professor Nana Abba Apia Amfo, the Dean of the University of Ghana School of Law, Professor Raymond Atuguba, the Director of Legal Education at the Ghana School of Law, Mr. Kwesi Prempeh Ek, the highly esteemed Deans of the Law Faculties in Ghana and abroad, distinguished members of the Law Faculties in Ghana and abroad, representatives of international development, the media, distinguished ladies and gentlemen, Your Excellency, may I crave your indulgence to recognize Professor Akila Kwapsoya. He was the Vice Chancellor who admitted me to the University of Ghana. Yes. It is indeed a great honor and pleasure to be here at my alma mater 41 years after completing LLB. I'm sure you recognize that the 41 years does not refer to me. It refers to Mr. Speaker. Which marked the first step in my journey to becoming a lawyer. It brings back the many fond memories of my course mates and I attending lectures and spending sleepless nights studying in the hope of one day becoming lawyers and joining the fraternity of learned men and women. I want to thank the University of Ghana School of Law for the opportunity to speak at such an auspicious occasion. The timeliness of an initiative such as this conference, which seeks to focus on forging a strategic direction for legal education in Ghana and Africa in an era of globalization, cannot be overemphasized. This is especially true given the role of the legal profession in the achievement of the Sustainable Development Goal number 16, which focuses on the promotion of peaceful and inclusive societies for the sustainable development of the provision of access to justice for all and the building of effective, accountable, and inclusive institutions at all levels. SDG 16 is particularly pertinent and relevant to the legal fraternity because we are the heart of the rule of law and justice. At the heart of the rule of law and justice ecosystem. If the rule of law and justice ecosystem